Most people think once a will is signed, it is finished. They imagine it sitting safely somewhere official, maybe in a lawyer's office or a bank vault, quietly doing its job. And that belief feels comforting. But here is the uncomfortable truth. How and where your will is stored can matter just as much as what it says. Is your will updated? And just as important, is it actually accessible when it is needed? Because a perfectly written will that cannot be found or released on time can leave your family confused, delayed, and vulnerable. Stay with me, because this is one of those details that sounds small until it becomes everything. My name is Judith Carver, and I am a senior protection educator. I am not a lawyer, and I do not give legal advice. What I share is educational information meant to help seniors understand common legal and financial situations so they can avoid unnecessary mistakes and stress. Laws vary by state, and only a licensed attorney or qualified professional can advise you on your specific circumstances. My role is to help you see the full picture so you can ask the right questions. And remember this always: your rights do not expire with age. Here is the thing. In the United States, there is no single national registry where all wills are automatically filed or tracked. Your will does not get uploaded to a government system, stamped, or stored in a federal vault when you sign it. Until the day of death, a will is usually a private document, and that privacy comes with responsibility. Someone must know exactly where it is and how to access it without delay. Many people assume that once a lawyer prepares a will, that lawyer automatically keeps the original forever. Sometimes that is true, but sometimes it is not. And this is where problems quietly begin. Law office practices vary widely by firm and by state. Some attorneys retain original wills in secure fire-resistant storage as part of their service. Others return the original to the client and keep only a scanned copy in their files. Over time, firms close, attorneys retire, offices merge, or records are transferred. If no one confirmed in writing who retained the original, families can spend weeks or months searching, calling former offices, and piecing together a paper trail that no longer exists. That uncertainty alone can delay probate and increase costs, even when the will itself was well written. Consider Helen. She remembered signing her will at a law office decades ago. When she passed, her children called the firm and learned it no longer existed. No one knew whether the original was transferred, destroyed, or returned. Weeks were spent searching. Stress filled the house. What should have been a calm process felt like a scavenger hunt. The lesson is simple. Never assume. Always confirm in writing who holds the original will. Now listen carefully. Notaries play a very limited and often misunderstood role when it comes to wills in the United States. A notary may be involved at the time of signing, especially when a will includes a self-proving affidavit, which is a separate statement that helps the court later accept the will without locating witnesses. The notary's role is simply to verify identity and witness acknowledgments. A notary does not review the content of the will, does not judge whether it is fair, and does not confirm that it complies with state law. Most importantly, a notary does not keep your will on file. A notary is not a custodian, an archivist, or a registry. Many seniors assume that once a document is notarized, it is somehow recorded, logged, or stored in an official system. That belief can create a dangerous, false sense of security. Once the notarization is complete, the document is handed back to whoever brought it, whether that is you, a family member, or an attorney. From that moment forward, responsibility for safekeeping belongs entirely to the document holder, not the notary. Pause for a moment. Think about safe deposit boxes. This is a common choice, and it feels secure, but it can create delays. In many states, a safe deposit box is sealed upon death until a court order or specific procedure allows access. If the will is inside, your executor may need legal permission just to retrieve it. That means time, paperwork, and sometimes attorney fees before anything can move forward. Some states allow limited access to retrieve a will, but the rules vary and banks have their own policies. What feels safe can unintentionally slow everything down. Here is where people get caught off guard. Keeping the will at home can be perfectly acceptable if done correctly. A fire-resistant safe, clearly labeled, with trusted people informed of its location, can work very well. Problems arise when no one knows where the safe is, or who has the combination, or whether the document inside is the final version. Families sometimes find multiple drafts, unsigned copies, or handwritten notes nearby. That creates doubt. Courts prefer clarity. One clear original, properly executed, stored in a known location, reduces disputes. This is where lawyers can add real value, and it is often overlooked. Many estate planning attorneys offer will safekeeping as part of their services, especially when they draft the document themselves. In these cases, the original will may be logged, dated, and stored in a secure, fire-resistant location within the law office or an off-site records facility. When the client passes away, the attorney releases the original will only after receiving proper proof of death and verifying the identity and authority of the named executor. This controlled process can prevent tampering, loss, or confusion about which version is valid. But this protection only works when it is clearly documented. You should have written confirmation that the attorney holds the original will, along with the firm's current contact information. Just as important, your executor should know exactly which attorney or firm has custody of the document. When no one is told, families lose time tracking it down. Silence creates delay. Clear communication creates efficiency and calm. Now stay with me. In some states and in certain counties, there is an option to deposit a will with the local probate court for safekeeping while the person is still alive. This can sound reassuring, but it is not a nationwide system, and it is not handled the same way everywhere. Some courts accept sealed wills, others require specific forms, and some do not offer this service at all. There may be a modest filing fee, and there are usually strict rules about who can retrieve the will and under what circumstances. Often, only the testator during life or the court after death can release it, which means family members may not have immediate access. Because many courts do not actively publicize this option, people often assume it exists when it does not. A local attorney can confirm whether this service is available in your jurisdiction and whether it aligns with your overall plan. Here is another overlooked detail that creates real problems. Copies matter, but originals matter more. A photocopy of a will can sometimes be admitted, but it raises immediate questions for the court. Was the original lost accidentally? Was it destroyed on purpose to revoke it? Was there a newer version that replaced it? Each unanswered question invites scrutiny, delay, and additional legal expense. Courts prefer certainty. When the original signed will is easily produced, the process moves forward with far less resistance. Let me show you something important. A self-proving affidavit, which is a notarized statement signed by the witnesses, can simplify probate in many states. It allows the court to accept the will without tracking down witnesses years later. This does not replace proper execution, but it smooths the process. Many modern wills include this, but older wills may not. That is another reason periodic review matters. Most people never notice this, but moving to a new state is one of the most important moments to review a will, even if nothing else in life feels different. While many states will honor a will that was validly executed elsewhere, that does not mean the process will be smooth. States have different rules for witnesses, notarization, and self-proving affidavits, and those differences can affect how easily a court accepts the document. Community property states treat marital assets differently than common law states, which can change how property is classified and distributed. Probate procedures also vary, with some states offering streamlined processes and others requiring more court involvement. Storage arrangements often need updating as well. Your original attorney may now be hundreds or thousands of miles away, and your executor may face added hurdles working across state lines. When your life crosses borders, your paperwork should follow. Alignment between location, law, and logistics prevents avoidable friction later. Now, listen closely. Telling someone where your will is does not give up control. It gives continuity. The truth is, in most families, the first problem after a death is not disagreement, it is access. If your executor cannot quickly locate the original will, they may have to start by opening an estate without it or proceed under interstate rules until the will is found, depending on the state. That creates delay, extra court steps, and sometimes unnecessary expense. So choose one or two trusted people. Your executor is the first choice because they are the person responsible for presenting the will to the court. A spouse can be appropriate too. An adult child may be appropriate when they are stable and respectful. The solution is simple but specific. Tell them where the original is stored and give them the name, phone number, and address of the attorney who drafted it if an attorney holds it. Many law firms either keep originals in secure storage or return originals to clients, so do not assume. Get written confirmation of who has custody. Here is where it gets practical. If your will is in a safe deposit box, that can backfire. Banks often restrict access once they learn of a death, and family members may need court authority, such as letters testamentary, before the bank releases contents. That can become a painful loop if the will itself is inside the box. A safer solution is to keep the original in a fire-resistant home safe or with your attorney, and keep only a copy in the safe deposit box, along with a card stating where the original is located. Another high-value upgrade is making sure your will is self-proved where your state allows it. A self-proving affidavit, signed by witnesses and notarized, can reduce the chance the court must track down witnesses years later, which can slow probate if witnesses moved or died. If your will is older, ask an attorney whether adding a self-proving affidavit requires re-execution under your state rules. Here is a calm checklist you can do without panic. Confirm who holds your original will and get that answer in writing. Confirm how it will be released after death and what proof will be required. Confirm your executor knows where it is and how to obtain it. Confirm there is only one original signed version, and destroy clearly marked superseded drafts in a safe, documented way with legal guidance. Confirming your will reflects your current life, including beneficiaries and who you trust to serve. If any answer feels uncertain, slow down, document what you know, and contact a licensed estate planning attorney in your state to align the legal rules, the storage plan, and the family communication. A will is more than words on paper. It is a system. Drafting, execution, storage, communication, and review all work together. When one piece is missing, families feel it immediately. Asking, is your will updated, also means asking, is it properly stored, clearly accessible, and legally sound where I live today? If something feels legally or financially complex, contact a licensed attorney or qualified professional who can advise you based on your circumstances. You deserve calm, clarity, and respect. If this information helps you or someone you love, share it. Many seniors struggle not because they were careless, but because no one explained these details plainly. Carry that awareness forward. Your rights do not expire with age.